which will this morning hear the urgent court interdict brought by Umkhonto weSizwe, which seeks to halt next week's Judicial Service Commission interviews. 2 weeks ago, the Western Cape High Court ruled that former Judge John Lawfare should be barred from participating in the process to select judges. That's pending the full judgment on whether Lawfare's designation to the Judicial Service Commission by the National Assembly was a decision that can be legally described as rational. On Monday, the official opposition sought to have the gathering postponed, but was turned down by the Commission on the basis that the court had contemplated the consequences of Lawfare not being a part of these meetings. The Newzroom Afrika's senior political reporter Ziyanda Ngobo on the ground already for those proceedings this morning. Ziyanda, good morning to you. Once again, it's Lawfare in South African politics, and this time it involves Lawfare, the JSC and Umkhonto weSizwe. It should be a very interesting morning.
Absolutely, and I think the courts have acknowledged that this is quite the quagmire that they find themselves in, Stephen. You have judges judging a former judge who wants to be a part of interviews for new judges, in essence. And today, of course, because it's an urgent court interdict, one of the first things that the MK party will have to prove is urgency. And now in their court papers, they're even asking for a punitive costs order because they're saying they've taken reasonable steps to actually prevent even bringing this matter before the courts, arguing that, of course, that matter on Monday to Chief Justice Monday Samai, who's the chairperson of the JSC, was an attempt to avoid this very issue. Now, of course, the MK party is arguing that the composition of the opposition parties that are sent to the JSC will be compromised by Lawfare's absence, and in fact that, you know, in the first time in this country's democracy, the appointment of designees by the National Assembly to the JSC was actually debated in Parliament. So that was the subject of a political decision in the first instance. But another issue we expect to be ventilated is issues around Section 18, Section 18.1, which basically suspends a court order once leave to appeal has been applied, and Section 18.2, which the respondents, the DA, Freedom Under Law, and of course Corruption Watch, they're likely to say, well, Section 18.2, which basically says you cannot appeal an interim order. Now, the JSC on Monday, Stephen, after receiving that letter, unanimously voted that they'll go ahead with those interviews because they believe that Part A of the Western Cape High Court judgment is an interim order because there's still Part B that still needs to be ventilated, and therefore they're invoking Section 18. It's an interlocutory application. Umkhonto weSizwe party is saying that cannot be the case because the effects of that order that was handed down on the 27th of September have the effect of a full order. Now, let's bring in the DA's national spokesperson, Karabo Khakhau, to talk about this, because it would seem that in the main, the MK party is saying, well, if you're going to stop Dr. John Lawfare from participating, then all the designees should not go, because they were all actually essentially voted for, because according to parliamentary convention, for the first time, this was even debated in the National Assembly.
Ziyanda, first of all, hello. Thank you for having me, and hello to your viewers. So you're right by pointing out that there's convention, not law. So that means that if the MK party wanted to stick to the convention, then they could have easily, knowing that Lawfare is compromised in this matter, appointed somebody else who can fill the benches there on behalf of the Democratic Alliance. But the problem here remains. On Monday, the vacancies in the Supreme Court of Appeal are going to be dealt with, and that is business that must continue, business that the other delegates or designates from the National Assembly or Parliament to the JSE will be able to continue with that mandate and agenda. And we think it's very important, and that process can't be halted. As far as today is concerned and his appeal, we believe it is an appeal that doesn't make sense. It is an appeal that is a fruitless exercise altogether. The High Court ruled in favor of the Democratic Alliance for a reason, because there's sobriety there, sobriety to our application. And we maintain, Ziyanda, that you cannot, and I think you pointed it out very beautifully, you cannot have a disgraced, impeached judge found guilty of gross misconduct now sitting in the same room with other judges who are also presiding on his appeal, on his impeachment, now sitting in a room to pick other judges who will also form part of an integral role of the judicial system altogether. So it's pretty much giving Lawfare a freeway ticket to say, go form your own army of judicial service servants in the country who you can get to manipulate in future, as you have shown that you have the capacity to do, and it's actually a will of yours, as was the case with the arms deal. Go sit in the same room, form your own army, and come back and erode further the trust that exists between the judicial service and South Africans. And that is something that we do not want. The man we maintain is not fit for the job. There's proof that shows that he isn't, and a political backdoor is not a solution to the problem. He shouldn't even be here to begin with.
I think the other argument that they're going to stress upon today, the MK party that is the fact that the second part of the judgment has not been concluded, which is looking at whether or not Parliament, the National Assembly's decision to even designate him to the JSC was rational. And they're basically saying that firstly, they've appealed Part A, which barred them, which they're saying that needs to be ventilated first before actually continuing with the JSC interviews. But in the main, they're saying, well, the courts have not made a determination yet on my designation. Therefore, why should I be excluded? I know Helen Ziller deposed her affidavit dealing with this issue. What did she say?
See, the principle here is this. Yes, Part A is yet to be heard and dealt with, but an interdict serves a purpose, and this is exactly why our applications had two parts, A and B, to say, while we get an opportunity to deal with Part B at the later stage and relook at the whole decision altogether, as a matter of urgency, given that the JSC is meeting on Monday and it shouldn't be moving their meetings because of Lawfare, because it's an important meeting, let us interdict it in the interim. So an alternative option could have been to say, okay, we are tied. Let us knock at the doors of Parliament and see if Parliament can't have an emergency sitting to replace Lawfare. But because we're dealing with a matter of an arrogant man who has absolutely no respect for the rule of law, absolutely no respect for democratic principles, absolutely no respect for the people of this South Africa, our land, that he is supposed to be a vanguard of, we are here.
All right, that's Karabo Khakhau there from the Democratic Alliance, one of the respondents in today's matter, alongside Freedom Under Law and Corruption Watch. And in essence, Stephen, this brings about a question that we continuously seeing, and I suppose in this matter it's even more highlighted about the fact that can the courts intervene or make comments on a decision, a political decision that was taken, and in this particular instance in Parliament. So it is that intersection between the law and politics, and you'll recall that when the JSC responded to the MK party, it was pretty much saying that they're trying to insulate a judicial process from the politics that may and should technically be ventilated in the National Assembly.
Zianda Ngcobo, part of our team covering that story for you this morning. Thank you very much indeed. We do